Good morning, everyone, and welcome to the last in our series of 4 that we are delighted to be hosting with Welby Assist. This morning we welcome Katy Anderson from our Duncan and Topless HR team. Katy has an HR career spanning 20 years and for the past 5 years has worked with our clients across varying sectors, providing day-to-day support and employment law advice. Today she'll be giving a high-level update on the upcoming changes for 2024 to allow employers to consider any policy changes that might be needed moving forwards. We'll then welcome Chris Jarvis from Welby Assist, who will be covering the final we statement, well led. If anyone has any questions, please do pop them in the Q&A chat and we will answer these at the end of each of the sessions. There'll also be a feedback form coming out, as there have been in previous weeks, so please also put any questions on there if you haven't asked them in the Q&A screen. So Katy, welcome, and I'll pass to you.
Thank you, Kay, and thank you everybody for having me today. As Kay has mentioned, I am going to be doing a very high-level overview of some of the upcoming employment law changes that are expected either to coincide with the beginning of the financial year in April, or a couple of changes that are anticipated to come into effect a little later in the year. I know that you have already, some of you heard from Damon Tunnicliffe, and he will have covered the statutory payments and national minimum wage, etc., from the payroll side of things. And so I won't be covering any of those, but if you need any further information, then obviously please do get in touch. So to start us off then, with some changes that we have been expecting for quite some time now. They were reported to be coming into effect back in 2022, 2023, and we have now had confirmation that royal assent has been received, and so it's important that employers are prepared for those changes in terms of their policies, documentation, handbooks, that kind of thing. Just really to make sure that we're keeping up with the times and operating in such a way that is consistent with the latest legislation. So I am going to start off with our family-friendly changes. So we are expecting changes to flexible working rights this year. With a change of entitlement from the previous 26 weeks of service. Flexible working requests will now be accepted from day 1 of employment. This may create challenges for employers in terms of advertising for roles with a certain with certain hours. Those roles could be accepted by a candidate, and then from day 1 of employment they could potentially request to change those hours to fit in with their lifestyles, to give them balance, to accommodate other responsibilities. And so it's going to be important to understand exactly what that means and how to respond to those requests. Now, what is important to remember is that this is a right to request. What that doesn't mean is that there is a duty to comply with that request, but so long as there is a justifiable business reason. There are 8 business reasons that can be given to decline a flexible working request, such as impact on quality, impact on the rest of the team, unable to accommodate specific hours at certain times due to workloads, for example. So as I say, it's not a right to work flexibly, it is a right to request flexible working. Another change in respect of the flexible working provisions is that 2 requests can now be made per year. Previously, and for a long time, it has been limited to 1 request per year. And so it's important to keep records of any requests that do come in so that you can make sure that you're fitting in with that timescale. Employers are required to respond to requests within 2 months of receiving that request. This is a reduction from the previous time limit of 3 months. Going back over the last 5-6 years, there has been a requirement for an employee to detail the impact that that flexible working request would have on the business, on colleagues, and on workloads, for example. That has now been removed, and there is no requirement for an employee to give those details as part of their flexible working request. There is a new duty for an employer to consult with that employee about those changes and about what they are looking for out of that arrangement. And so what we mean by consulting with those employees is having a meeting, arranging a formal meeting to discuss the request, to understand the implications of that request, and to either agree or negotiate some kind of other arrangement that the business could potentially accommodate. And so it is important to have that two-way conversation to make sure that your understanding as a business owner and employer is correct, first of all, and secondly, so that you can respond to that request appropriately and think about any other options that might be available if the business cannot accommodate that original request. So the thing that we would recommend is that any flexible working requests are put in writing and are also responded to in writing. This ensures an audit trail of requests, along with, as I say, a record of when those requests are made to ensure that you're compliant with that legislation. Secondly, some changes to paternity leave provisions, which haven't changed for a long time, and so it is important to bear these changes in mind. They are fairly simple, but they do have sort of wider stretching implications on that employment relationship. Previously, paternity leave has always been taken in blocks of 1 week or 2 weeks in one period of time. That has now been extended and can now be requested as 1 block of 2 weeks or 2 blocks of 1 week. The timescale for which paternity leave can be taken has also been expanded, and paternity leave can now be taken within the first 52 weeks after the birth of a child or the placement of an adopted child. And so whereas historically we tend to see paternity leave taken for the 2 weeks immediately following the baby's birth, that has now been quite significantly expanded to allow fathers to take that time at any point within the first 52 weeks of the birth of the child. This has very recently already come into effect on the 8th of March, but for babies born after the 1st of April. And this is to allow fathers to give the 28 days notice required. Now, the 28 days notice is also quite a significant reduction on the previous timescale of 15 weeks. And so the notice to be provided by a father now has been shortened to 28 days. So on now to a brand new provision, and this area of employment law has been much talked about over the last couple of years, and we have had quite a strong indication that this new provision was going to come into place. Arguably, there's a lot of sectors which feel that this statutory provision does not go far enough, and what that means is that we may see changes to this over the coming years. But as it stands at the moment, the new right to carers leave is going to be introduced on the 1st of April. This provides all employees from day one of employment to 1 week's carers leave per year. Entitlement to leave is unpaid, and so there is no obligation to pay for that leave, although employers may choose to offer that as an enhanced benefit. That would be absolutely discretionary to each business. Applications for carers leave extend beyond immediate family members. There's a common misconception that a carer is specifically caring for somebody who they are closely related to, and that's been made very clear in the legislation that this is not the case. More often than not, I would assume that it will be the case, but it is important to remember that carers leave applies to a much wider range of people who are receiving care from your employees. That could include a neighbour. It could include somebody who lives at the premises but is not immediately related to that person. Leave can be taken in chunks of 1 week per year. It can also be taken in periods of 1 day at a time or half a day as well. It is important to note that 1 week is equivalent to that employee's working week. And so if an employee works 3 days a week, then their entitlement to carers leave would be 3 days per year. There is an obligation to consider a request for carers leave, but employers do have discretion to negotiate on the period of time that is taken for that carers leave if there is a justifiable business reason. For example, if the time requested to take carers leave falls at a significantly busy time of the year for the business, then there absolutely can be a negotiation about the time period which is taken. Employers can propose an alternative date for that carers leave to be taken, but that alternative date should fall within 1 month of the originally requested time. So it's just important to remember those timescales and to accommodate those wherever possible. Finally, then, in terms of our family-friendly changes, there, as I'm sure many of you will know, has always been increased protection for employees who are on maternity leave against redundancy situations, and an entitlement to be given a priority over other colleagues in such circumstances when being considered for redundancy. The timescales by which that protection applies has now been extended, and so employees are protected from the very moment that they inform their employer that they are pregnant, so not when they start their maternity leave anymore. And this protection continues for 18 months after the child is born, which obviously expands that timescale by quite a considerable amount of time. Therefore, if businesses are considering redundancies and a pooling of staff for consideration for those redundancies, then it is really important to now consider anybody who may have returned from maternity leave or who has informed you already that they are expecting, because you will need to put additional layers in place to accommodate those people and protect them from any kind of detrimental treatment as a result of that redundancy process. This policy also applies to any women who have suffered a miscarriage. The timescale restrictions do apply to that, although I have to be honest and say that the legislation has not been completely clear as to what those timescales are. But please do consider that anybody who unfortunately has suffered a miscarriage with you, who may be put at risk of redundancy, will also fall within these additional protections against discrimination. Okay, so moving on to a couple of other changes in relation to pay and benefits. We have now seen the return of rolled up holiday pay. This is something that has more recently been considered quite an old school approach, if you like. Holiday pay has historically been rolled up for certain staff and workers, and over the last 5 to 6 years there has been much more in the media about the legalities of doing that. Now, the legislation going forwards from the 1st of April is very clear that rolled up holiday pay will again be acceptable. The reason for this is to address the impracticalities arising from the Harper versus Brazel case, which was very much reported in the media last year in terms of a part-time school worker who took her case to the Supreme Court and won her case based on a part-year working arrangement. So this is applicable for casual workers, part-year workers and irregular workers. And what this means is that you can offer financial compensation in place of holiday provision. The case last year raised lots of questions in the legal world for human resource experts and employment law experts, and that luckily now for us has sensibility has prevailed, and we now have a little bit more discretion in doing so. We are also seeing a return of the 12.07% holiday accrual calculation. This has been a very grey area in the legislation for quite some time now. Probably 3 to 4 years has been the length of time where this has been largely debated as to whether it's an acceptable calculation or not. Legislation from the beginning of April will make it very clear that legally this is absolutely fine. We can all return to 12.07% calculation. And again, this is in respect of those casual workers, part-time workers or irregular hours workers. We wouldn't see the 12.07% be applied for full-time permanent staff. That's not what the intention is. And I've just given you an example there on the slide with regards to what that 12.07% means. And what it means is that for a worker who would ordinarily be entitled to the equivalent of 5.6 weeks holiday, that worker would accrue 7.242 minutes of holiday time for each hour worked. It's just quite a handy calculation for the purposes of your admin. So the following changes are not anticipated at the beginning of April 2024, but they are likely to or have been confirmed to be coming into effect a little later in the year. And I have included the dates on the slides for you as well. TUPE consultation changes. So from July 2024, businesses with less than 10 employees affected by a TUPE transfer or with less than 50 employees in total will no longer be required to elect representatives for the consultation process and will be able to consult with employees directly. This is really to enable and support small businesses who are running fairly standardised or basic TUPE changes or transfers. Generally, we see these under the umbrella of the same business types, and it just gives a little more flexibility to navigate those processes. So, as I say, not into effect yet, but coming into play in July 2024. So important to keep an eye out for those changes coming into play, and hopefully we will receive a little bit more guidance ahead of those times because the publications have been fairly limited to date. Allocation of tips in the hospitality trade. This has been, again, a much talked about area of employment law, specifically relating to hospitality over the past 12 to 18 months. And it has been confirmed that this will be adopted in July 2024. What this means is that from that date, tips must be allocated to workers in a fair and transparent way. I would advise that there is some kind of brief policy in place to make very clear how tips will be allocated and what the process is for doing so. Tips must be paid to employees within 1 month of the end of the previous month. It's really important to stick with those timescales unless there is a good reason for not doing so. There is some flexibility around business justification, but as a guide, 1 month following the month in which those tips were collected. Employers need to keep accurate records of tips, and these records need to be made available to employees upon request. And so there is a little bit of admin, unfortunately. I know that we are all drowning in admin at the moment with all of the various other things that we have to do. But it is now going to be a requirement to keep records of all tips collected and how they've been allocated to your staff. Okay, so coming up again, I do apologise, coming up again in October 2024 is an increased obligation on employers to proactively prevent sexual harassment in the workplace. Now, there's limited information. We are still expecting some further information to come out on this policy, but where I would advise to start as a starting point, if not already in place, would be to consider employee training on sexual harassment and bullying. Make sure that you have appropriate policies and procedures in place for dealing with any reports of sexual harassment and or bullying. Be mindful and make sure that any workers are mindful of office banter. Office banter is one of those areas that unfortunately I do still deal with quite a lot. I think we're all much more in tune now with sexual harassment and what consists of sexual harassment, but office banter can very much start to cross that line between having a laugh and a joke with a colleague to potentially being offensive, and that doesn't mean necessarily to the person that is receiving those comments. That could be anybody that's in the area at the time, and so it is very important to make sure that staff are aware of how office banter can land with other people. They might have a really good relationship with a colleague and they may feel that a joke is appropriate with that person, but it's important to just be aware of other people that are around, whether that's colleagues or visitors or customers, anybody really within the vicinity. And finally, on that point, to cultivate a culture where respect and accountability are at the forefront of everybody's mind, it just goes some way to limiting the chances that you're going to end up having to deal with a sexual harassment case, because let's be honest, nobody wants to be dealing with that nowadays. We've done a lot of work over the last few years, and I'm pleased to say that cases are significantly reducing, but unfortunately it does still happen, and more often than not that is unfortunately down to misplaced banter or having a joke with a colleague, and that goes wrong, unfortunately. Okay, so the final couple of points, the right to predictable working is coming into play in October 2024. Now this particularly will apply to agency work, not agency workers, I do apologise, 0 hours workers, casual workers, irregular hours workers, those people who don't necessarily have a structured work pattern. And this will be only applicable to anybody who has 26 weeks or more service. And what this means is that those staff members will have a right to request a more predictable working pattern. The reasoning behind this introduction is to allow those workers who do work flexibly and casually with organisations to be able to achieve a bit more of a balance in their lives. Unfortunately, there are some employers that will use a casual or an irregular hours worker and the agreement with those workers to dictate very much at the last minute any changes, any additional hours, any cancelled shifts. And this can really have a detrimental impact on an employee's ability to budget, organise their time, juggle their family commitments. And so that's why this new piece of legislation is being introduced a little later in the year. It is anticipated that employers will be able to reject a request, and this we anticipate will be based on a number of lawful reasons, similar to a flexible working request. However, unfortunately, these have not yet been confirmed. We are keeping an eye on out for legal updates, and we will communicate as soon as we have that information by way of our usual newsletters, etc. And finally, we are to see the introduction of a new provision in October 2024, which will allow parents of babies who are admitted to hospital before 28 days old and for at least 1 week. And these people will receive a maximum of 12 weeks leave, which would be paid in line with the other statutory payments such as sick leave and paternity leave. And this is in addition to maternity and paternity rights. Again, unfortunately, this is one of those areas where we are awaiting further details. We are just trying to get ahead and let you know what changes are being anticipated a little later in the year. In terms of the changes that you can see on your slide at the moment, I would say there are no immediate actions or no urgent actions, I should probably say, but it's always good to be prepared. And so certainly in terms of policies, handbooks and that kind of thing, it's worth starting to think about reviewing those policies. If you don't have policies in place, it's worth starting to think about getting those policies in place to make sure that you're able to comply with the legislation that's expected a little later in the year. So that's all from me for today. I appreciate that has been a bit of a whistle-stop tour. We have given the headlines, but if anybody would like any more information about any of the legislative changes that I've talked about today, then please do absolutely feel free to get in touch. I'm more than happy to have a chat. But otherwise, I will hand back to Kay, and I will stick around in case there's any questions at the end of the session. So thank you very much for bearing with me. I am extremely bunged up today, as I'm sure you can probably tell, but I've survived and I hope it was useful. So thank you.
Thank you, Katy, for that very informative update. Obviously, staffing is the biggest cost a practice has, aside from dispensing practice's drug costs. So really important to know your rights and those of your employees. We do have one question. Carers leave, Katy. Do employees have to declare that they are a carer and provide any evidence?
That's a good question, and actually surprisingly the answer is no. There is no requirement to evidence the fact that you are a carer. Now obviously that potentially opens the policy up to be abused, unfortunately. We would obviously hope that that is not the case, but the legislation is very clear that there is no evidencing requirement in terms of that particular legislation. What I would recommend is two-way open communication with those staff members to really understand what the caring situation is, how that person is involved with the person that they care for, and what impact that potentially has on their day-to-day lives. And I think that's one way that we can try to mitigate those odd cases which may or may not be trying to abuse that provision. So I would hope that would be very few and far between. But again, I think that can be reduced by having those conversations and really trying to understand what that person's dealing with.
That's super. Thanks, Katy.
No problem.
Don't have any more questions at the moment, so I will now welcome Chris Jarvis. So Chris is a former CQC inspector and brings a wealth of expertise in healthcare regulation and quality assurance, having dedicated 11 years to the CQC as an inspector. His extensive experience as an ex-CQC inspector has equipped him with unique insights into the intricacies of compliance, allowing him to provide valuable perspectives on how organisations can meet and exceed regulatory expectations. Chris is now dedicated to sharing his knowledge and insights with others, whether through mock inspections, staff education, or hosting webinars. He continues to contribute to the improvement of healthcare quality by empowering individuals and organisations with the information they need to navigate the ever-evolving landscape of healthcare regulation. So thank you, Chris. I'll hand over to you.
Thank you, Kay. Hope everybody can hear me okay. Well, good morning, everybody. A bit of CQC business first before we get on with the matter in hand, and that's about the new CQC portal. The CQC portal for the Midlands region went live yesterday on the 12th. You have every provider needs to register on the new portal as soon as possible. The old portal will stay active or live, if you like, until the 31st of March, on which they'll be switched off and any information on it will be lost. There's no automatic transfer from the old portal into the new portal. You have to physically go onto the CQ website and register your interest, or not register interest, register on the new portal. In that intervening period between now and the 31st of March, whilst you will be able to access the old portal, you won't be able to add any information to it. So, for example, if you've got a change of partners or a change of location or regulated activity, or you need to submit a statutory notification for death or something like that, or police involvement, you won't be able to do that through the old portal. It has to be done through the new portal from today onwards. So I would urge you all to get on there, look on the CQC website. It's quite clearly marked on there about the need to activate your new portal and get on with it. It's got to be the email address you use must be that of either registered manager or the nominating individual. So if you do it on their behalf, make sure you use their email address. Any questions on that before I go any further? Can you say anything, Kay? Okay.
No questions come through yet, Chris. No.
Thank you, Kay. Okay. Yeah, so nothing's much changed. The new assessment process for the Midlands region, which includes Lincolnshire, Nottinghamshire, Derbyshire, and Leicestershire, went live early this month, 2nd, I think, 2nd of March. So if you do get an assessment, it'll be under using the new process, even though the inspectors haven't done the training on how to do it yet. So that'd be interesting. My understanding is that as yet there have been no inspections scheduled. The only inspections will take place are those based on risk, and that process is continuing. That process continuing up until the end of June, when there'll be a revision of what's happened, what's gone well, what hasn't gone so well, and any changes they need to make before the whole system goes live in July. And there'll be a statement from the CQC setting out the provisions that are going to follow from July onwards. So at the minute it's as you were, but I would urge you all, as I said before, there is I would just make sure you've got your ducks in a row, you've got everything where it should be, just in case you get an unannounced CQC assessment. I'm not going to use the word inspection anymore, because inspection is written out of the CQC vocabulary. So the new assessment relates to, as far as we're concerned, this call, it relates to primary medical services, which includes GP practices, independent doctors, and some other independent health providers. And the process and the quality statements are exactly the same for all of them. Okay, but if you look on CQ's website, I'll tell you which ones relate to which. So I'm just going to move on to well-led, and well-led's always been. Sorry, somebody's still on the keyboard. Well, it's always been a catch-all really in the past for gathering evidence and doing ratings, because a lot of the things that you do that are covered in assessment of the other key questions actually falls into well-led as well. And the obvious example is about safety. So if a practice is found to be unsafe, for whatever reason, it might be a matter of infection control or something like that nature, it's self-evident that if it's not meeting requirements in the safe domain, it won't be meeting the requirements in the well-led domain, because one follows the other as sure as night follows day. So and that's not changed in some respects. So other than that, the well-led key question is now a bit more specific, and it really is looking at leadership rather than systems so much. So one of the first one, the first question, the first quality statement is about shared direction and culture, and that's shown up on the screen now. I'm not going to read it, you can all read yourselves. And for that particular question, the inspector will be looking at two evidence categories. The first is feedback from staff and leaders, and the second one is process. So feedback from staff and leaders is about results from staff surveys and feedback from staff to their own employers. Individual interviews or focus groups that CQC inspectors may hold with members of staff. Interviews with leaders themselves, whether it be practice managers, partners, or whoever. Feedback from people working in the service sent to our Give Feedback on Care service. So what that's like, on the CQC website, there is a button for Give Feedback on Care, and members of the public and staff are quite encouraged actually to give feedback on care through the CQC website, and of course whistleblowing. So they're the 5 categories that assessors and inspectors will be looking at when making an assessment of whether you must meet the requirements of the shared direction culture. As I've said before in previous webinars, each of the key questions, each of the evidence statements in each of the key questions is assessed against a specific number of the evidence categories. So there's, I think, 6 evidence categories, and CQC inspectors are instructed that they will only look at specific evidence categories for each of those statements, as I said. So for this one, which was shared direction culture, they will only be looking at feedback from staff and leaders and processes. And the processes covers all sorts of things. It does actually cover things like proper investigation, recording of complaints and serious events. It talks about clinical outcomes to an extent, but it really is about how the process actually works. It also includes access times for treatment and care, and some case review as well of people's notes. So that's that. So move on. Capable, compassionate, inclusive leaders. So this is pretty self-explanatory. Again, only using 2 evidence categories, which is feedback from staff and leaders and process that we've just discussed. Room to speak up. This is talking about positive culture, and you know, I've been to many practices where it's been quite obvious there's been quite a close culture, and doesn't work very well really. So so again, just the 2 evidence categories: feedback from staff and leaders and processes. Moving on, next one is workforce quality, diversity, inclusion. It's exactly what it says on the tin. Again, just the 2 evidence categories: feedback from staff and leaders and process. Moving on, governance management and sustainability. We're not talking about environmental sustainability here. We're talking about sustainability in practice or the organisation that's been inspected and been assessed. Again, just the two evidence categories: feedback from staff and leads and process. Partnership and communities. Again, it is exactly what it says. And so they're a little bit different. The evidence categories here are talking about people's experience with health and care services, feedback from staff and leaders, and feedback from partners. And when it says partners, it doesn't mean GP partners. It means partners such as commissioners, other regulators, for example, all that sort of thing. And process, again. Moving on, learning, improvement, innovation. So this is about encouraging ways, showing that you're being creative, encouraging people to better themselves and better the practice. Again, evidence category of feedback from staff and leaders and process again. And finally, the one which is totally new is about environmental sustainability. It's not something that's ever been assessed or looked at by the CQC before. I understand that CQC aren't absolutely positive or set in their minds about how they're going to look at this, how they're going to assess it, and even actually whether they're going to use it as part of the rating process because it's so new. But I think it's something that we should all be doing. I mean, on last week's webinar, there's quite an interesting speaker from Duncan Topless about sustainability, and it made me think about a little bit about what we could do to make those positive contributions. So that's the one thing I just want to talk about a little bit, and know about what you could do to tick that box. And it could be as simple as changing light bulbs throughout for low energy LEDs and whatnot. If you have company vehicles, where you should be thinking about changing those to electric or hybrids when they come around for renewal, those sort of things. And whether actually working from home on odd occasions is something you could do to save the carbon emissions on commuting to and from work. What I would say is that I think it's worth sitting down and thinking about that. Although I'm pretty sure, the CQC aren't going to come and say, oh, well, you're not meeting sustainability targets, because there is no target, but not meeting sustainability requirements. But if it was me in your position, I would sit down and think about this and put together a plan going forward. That as things come up for renewal, you will renew them with sustainable things, like as I said, like light bulbs or getting rid of plastic cups out of your water fountains and this sort of thing. So all those sort of things, just to show the CQC inspector when it turned up that you have thought about it and you are trying to make a positive contribution to sustainability. I've got nothing much more to say really. Other than, there's that. So I had the pleasure of going to a mock inspection, if you like, and Jackie has kindly written a testimonial, which I'll just give you a minute to read before we move on to any questions. Any questions? Hey, you can send them.
That's super, thanks. Thank you very much, Chris. There is not anything at the moment. I will just read out a question that was I'd noticed after you'd started that came through for Katy, just so that if anybody else had a similar question. They'd asked about the 12.07% holiday calculation, and if they offered 7.2 and 7.6 weeks, what would that percentage be like? So Katy's just replied to them to say that 7.2 weeks was 15.4%, so 9.2 minutes accrued for each hour worked. So those calculations can be done and adjusted depending on what your offering is. Has anybody got any questions for Chris? There's nothing popped up at the moment. It's all very quiet. Chris, you've done them into silence again.
Yeah.
That was great. Thank you very much. Well, if anybody does have any questions, then as I say, you will be getting feedback forms. So if you haven't put your question on here or you think of anything afterwards, then please do just add it to the feedback forms. So I'd just like to thank Chris again. Obviously, we've had 4 weeks of joining you and providing some webinars that hopefully everybody has found useful. Thank you, Katy, for joining us today with the HR update. So I shall let everybody get on and enjoy the rest of their day. And as I say, please do fill those feedback forms in, because it's really helpful for us to know what we can put on that you'll find helpful, how you found the ones that we've put on so far. Thank you very much. Bye.
Thank you.
Thank
Bye.
you.